Oh, there we go. Better. Dangerous sex offender requiring confinement means a person who is a detained sex offender. Dangerous sex offender requiring confinement means a person who is a detained sex offender suffering from a mental abnormality involving such a strong predisposition to commit sex offenses and such an inability to control the behavior that the person is likely to be a danger to others and commit sex offenses if not confined in a secure treatment facility. If the person is referred to a case review team, notice of the referral shall be provided to the respondent. Upon such referral, the case review team shall review relevant records, including those described in sub C and D, and may, so they shall review the records and they may arrange for a psychiatric examination of the respondent. Based on the review and assessment of the information, the case review team shall consider whether the respondent is a sex offender requiring civil management. Okay, so now this is all on the case review team because it says if the case review team determines that the person is not a person requiring civil management, they notify the Attorney General and the Attorney General shall not file this petition. Okay, so it's the case review team thing that actually makes a determination whether or not the sex offender requires civil management. 1006 says petition and hearing. So I'm assuming now it's going to go into when the sex offender does require civil management. The Attorney General may the Attorney General may file a sex offender civil management petition in the Supreme Court or the County Court. In the Supreme Court or the County Court where the respondent is located. So not where the original criminal action was. It's where the respondent is located. If the Attorney General elects to file this petition, they shall serve a copy of the petition on the respondent. And the petition shall contain, now this is what the petition shall contain, a statement or statements alleging facts of an evidentiary nature. Upon receiving notice from the case review team that the person is a sex offender requiring civil management, the Attorney General may file a petition in either the Supreme or County Court where the respondent is located. So most of the time this would be an incarcerated person serving upstate time, and so they would be filing it in some county court or whatever, Supreme or County Court upstate. Now, the Attorney General shall seek to file the petition within 30 days after getting the notice from the case review team. The Attorney General shall seek to file the petition within 30 days after getting the notice from the case review team. The Attorney General shall seek to file the petition within 30 days after getting the notice from the case review team. But it's a very soft 30 days because it says that failure to file within that time period does not affect the validity of any petition that gets filed. So, now if the respondent, now we're calling him the respondent here. So the respondent gets this notice that there's going to be a petition filed or gets notice of the petition. The sex offender or the respondent can file something like a notice of change of venue, basically. 10 days for the respondent to file a notice to move, then 10 days for the respondent to file to the county where the criminal action was. If the Attorney General doesn't like that, the Attorney General can then file a motion within 5 days. And the time could be extended for good questions. So basically, the time rule so far that I have, and I got all of these questions wrong on, someone had like index cards, and I got all of these questions wrong. So it's a 30 days from when the case review team sends the Attorney General the notice. He's got 30 days to move, but it's a soft 30 days. Then 10 days for the respondent to file a notice to move the case. And then it's 5 days after getting the notice that the respondent wants to change the venue. The Attorney General then has only 5 days to actually make a motion to retain, for retention of venue. It's called a motion for retention of venue, and the Attorney General's got to make it within 5 days of getting served with the notice to change the venue. But the time can be extended for good cause shown. For retention of venue. It's called a motion for retention of venue, and the Attorney General's got to make it within 5 days of getting served with the notice to change the venue. The court shall appoint counsel in any case where the respondent is indigent. The court shall appoint the mental hygiene legal service if possible. The court shall appoint the mental hygiene legal service if possible. So the first shall is that the court shall appoint counsel if the person is indigent, and the court shall appoint the mental hygiene legal service if possible. The Attorney General may request the court in which the sex offender civil management petition could be filed or is pending to order the respondent to submit to an evaluation by a psychiatric examiner. So that's a may. Or is pending to order the respondent to submit to an evaluation by a psychiatric examiner. The Attorney General may do that. At any time after the filing of a sex offender civil management petition and prior to trial, because yes, in this article, there will be a trial and it will be a jury trial with 12 people, 12 jurors. Oh, it's coming. And then it says, upon such request, the court shall order that the person shall order an evaluation by a psychiatric examiner. So it's a may for the Attorney General. The court so far has got 3 shalls in here. Shall appoint an attorney. Shall appoint the mental hygiene legal service if possible. And shall order the evaluation if the AG requests it. Notwithstanding any provision in this article, if it appears the respondent is going to be released during this and the Attorney General determines that the protection of public safety requires, the Attorney General may file a securing petition. In that circumstance, there shall be no probable cause hearing until such time as the case review team may find that the respondent is a sex offender requiring civil management. If the team finds that he's not, the Attorney General shall so advise the court, and the securing order petition shall be dismissed. Notwithstanding any provision in this article, if it appears that the respondent is going to get out prior to the time that the case review team makes a determination, the Attorney General can file a securing petition. The Attorney General may file a securing petition. The Attorney General may file a securing petition. In such circumstance that the case review team finds that they don't need the civil management, then the Attorney General shall notify the court and the securing petition shall be dismissed. Within 30 days after the petition is filed, or within a longer period as the respondent consents to, the Supreme Court or County Court before which the petition is pending shall conduct a hearing to determine whether there is probable cause to believe the sex offender requires civil management. Within 30 days after the petition is filed, or within a longer period as the respondent consents to, the Supreme Court or County Court before which the petition is pending shall conduct a hearing to determine whether there is probable cause to believe the sex offender requires civil management.